chairman of Waiver Conference, we organized this event. And so this event is organized on the back of an organization I have been leading and running for almost 10 years now, because we had our very first conference in this room in June of 2009. So we're here today and tomorrow for the construction law seminar. We're going to have a keynote address today and tomorrow. And that keynote address is going to be given by Dr. Ron Watermeyer.
So what I'll cover is just first of all looking at what risk is, because I think infrastructure space is full of risk, and I see risk as uncertainty upon objectives. And of course, that's what clients want, is you have an objective, you want to deliver a project within those objectives. I want to sort of talk about forms of contract that can be used by clients to mitigate their project risks. So I'm really talking at a high level. And I would like to link project and procurement objectives to the selection of a standard form of contract, and to just touch upon two case studies which just highlight two major projects in South Africa that had the same objectives and had very, very different outcomes because different tools were used. Now, I am aware of it that in Ghana, in the public sector, you do have a procurement act, and it requires that you use appropriate standard tender documents stipulated in a schedule, which is really just the names of the documents, and then you would go and use those documents to apply in your particular environment. And I think you're coming from a philosophy of you've pre-selected a form of contract and you hope it meets your objectives. So I think it's a bit of a rigid approach, so maybe I'm trying to open up the horizons to think differently and see, are there alternative approaches to achieve the same end objectives.
Hello everyone, how are you? It's nice to be back again. We become too focused on assuming something has to be done in a particular way, on thinking that it's the only way. You need to see time and cost in context here. Time and cost have a very different meaning in the way Ron was talking about doing some of the projects in collaboration with each other, to others where you have the more traditional master and servant type approach in a construction contract. So very often we get stuck in time and cost discussions simply because we are so used to dealing with typical lump sum or immeasurable contracts. It's a very different mindset when you're dealing with a different type of procurement arrangement. So understand that when we're looking at time and cost, we very often contextualize it within what we're used to dealing with. And it's very difficult to try and understand it in perhaps doing it in a different way.
So subject to what the terms of the contract might say, some of the typical claims associated with time are set up there on the slide. Employers claim for liquidated damages, compensation claimed by the contractor for delayed or disrupted work, acceleration claims, and so on. Now, time and money are very key areas of overspend on construction projects, and they're a very common battleground. I'd say 90% of the disputes, the arbitrations that I'm involved with, there will be an argument, dispute over entitlement to time, claims for extensions of time to get the relief from liquidated damages, and indeed claims for disruption. So to be effective, as we've heard, extension of time provisions need to allow an extension for any act or of prevention or hindrance by the employer, and the Society of Construction Law Protocol recommends that they should also set out and explain the consequences of failure by the contractor to comply with the specified procedure.
Now, there's no perfect construction. There's virtually no construction that meets the exact deadline. And there's no construction that will not go over time or increase in cost. Possibly there may be a reduction in cost, but these are rare. Now, delay and disruption is often a subject of litigation, a lot of it. And a number of them are matters that are resolved by arbitration or by the internal mechanisms that are put into the contract for resolving some of these things. And most of it is just a common sense approach.